What if I told you that most people don't lose in court because they're wrong? They lose in court because they walk into a battlefield holding the wrong weapon. You flip the contract open. And what if I told you that the most dangerous traps in any loan, contract, or credit agreement aren't hidden in the fine print? They're hidden in the consideration. This is episode 4, where we're going to talk about the top 5 consideration traps that get people destroyed in court. Now, every case, every dispute, every argument eventually comes down to one thing. Can they prove lawful value under the law? But most people don't know the rules. So they walk into court thinking that they're fighting fraud, but the reality is that they should be fighting the failure of consideration. Today, I'm going to be teaching the traps that wipe people out and how to avoid every single one. Now, before we dive into this video, remember to hit the like button, remember to hit the subscribe button, tap into the channel. Number 2, this is not legal advice. This is not financial advice. Do your due diligence, okay? I understand that people can get excited about this because on this channel, we're built to talk about the economic truth. And the economic truth may push people to be emotional when it comes to debt discharge, to be emotional when it comes to their promises and their contracts. But I'm here to also teach you the legal reality, the legal truth, and how they coexist with the economic truth, okay? So that you're not caught up in emotion and you're focused on actually winning the battle and understanding the system that you are in. So make sure you stick around all the way to the end because we're going to be dropping game that nobody is talking about. So let's dive into another one. One of the first place I want to start by talking about is the first trap, which is the fraud argument. Okay. Now, first, let's just talk about what fraudulent misrepresentation is. Okay. Under the restatement, second of contract, section 164, it says a fraudulent or material misrepresentation is a false statement of fact or concealment that is either intentionally deceptive or likely to induce a reasonable person to enter the contract. The recipient of the misrepresentation must have justifiably relied on the false statement. And the voidable element of the contract is voidable by the recipient of the misrepresentation. So it does explain, that's the AI version, but obviously if you want to come and take a look at it, this is the most dangerous trap of them all, okay? Saying that fraud is emotional is a trap within itself, unfortunately, all right? Fraud requires intent, meaning you have to be able to prove that they intentionally tried to defraud you. And fraud requires proof of deception. The reality is that credit extension would not be considered fraud, okay? But the lack of disclosure of the contract can be considered fraud, but you wouldn't really be arguing about fraud. You'll be arguing about the lack of disclosure. In order for something to be fraudulent, the restatement second of contract says that it must be misrepresentation. It must be intent. It must be a reliance on that fraudulent, and it must cause actual harm. The thing is that you would not be able to prove a bank's intent ever. So courts throw these arguments in the trash. Really, really hear me when I say that. You have to be able to prove intent, and it's going to be impossible for you to be able to prove intent. Does that make sense? Okay. So then that brings me to my next point. I want to directly tell you to not fight fraud. It is true that they are being fraudulent. It is true. But your argument cannot be fraudulent, okay? Fight failure of consideration and non-disclosure. You see how the argument shifted from being about fraud to now talking about actual concepts and principles that are in the Constitution, that are in legal doctrines, okay? So if this is finally clicking, this is exactly why I built the Fund Yourself Academy. Not to complain about the system, but to teach you about contracts and UCC rule, okay? To teach you about structure and documentation. To teach you about how to actually shift the arguments and narratives in your favor, okay? If you're looking to operate with clarity instead of confusion, the link is in the description below. Tap into the Fund Yourself Academy. If you truly want the resources, templates, extended help, Tap into the Fund Yourself Academy. It's only $27 a month until Christmas Day. Tap into the Fund Yourself Academy, and I'll see you in the community. So let's get into trap 2. The other trap is using the argument, no money was lent. This is probably one of the most famous traps online because we do talk about the fact that money isn't lent, but it's only put in place to empower you to go ahead and challenge them on these. The fact that money isn't lent is just affirming for you to go ahead and do the due diligence, because if you do the due diligence, it's probably going to be a lot of things that they will be unable to disclose, which will put them in a position to lose their end of the case, to be unable to enforce the documentation. But the thing is, when you go in there and your argument is no money was lent, there are case law out there where, yes, this proved to be a legitimate thing, but it wasn't a good case or a good argument for that person to win in court. Okay? So when usually people will argue that banks don't lend deposits, banks create money from signatures, and banks never risk their own funds, which is economically true. It is true that the fact that banks don't do what they tell you that they do. But here's where you start to change the frame, okay? This is when you pivot, because even though this is true, and even though that it probably won't be able to hold up in court as an argument, it's more an element of how you can frame it so that you can use it to your advantage. Economic truth is not legal truth. Courts enforce legal structure and not the economic reality. So first thing I want to show you is the actual law. Number 1, UCC 1-201, specifically breaking down the definition of money. It says that money means a medium of exchange currently authorized or adopted by a domestic or foreign government. The terms includes a monetary unit of account established by an intergovernmental organization or by agreement between 2 or more countries. It says that money is what the system recognizes as the medium of exchange. This also includes the bank's credit. But then if we go down a little bit further, where it talks about the element of security interest. Security interest means an interest in personal property or fixtures which secures payment or performance of an obligation. The bank relies on legal rights, not cash. So the point of me bringing this up is so that you can also rely on your rights and not just cash. And then the other element, the other law, the other truth, the other legal doctrine is modern money mechanics. And we talked about that in my previous videos, how modern money mechanics explain that loans are merely just bookkeeping entries. So yes, it is true that no money is lent. It is true that they are just extending credit. It is true that there is legal doctrines that prove this, right? But here's what I want you to understand. You don't want to argue that no money was lent, because court will treat bank credit as lawful consideration because it operates within a recognized commercial structure. The win will come from a different angle, and I'll explain that later. Let's get into trap number 3. And we talked about this in my previous video about illusionary promises, okay? Under the second restatements, second of contract, section 77, it breaks down what illusory and alternative promise is, okay? It says a promise or parent promise is not consideration if, by its terms, the promisor or the purported promise reserves the choice of an alternative performance unless each of the alternative performances would have been consideration if it had alone had been bargained for, or one of the alternative performances would have been consideration. And there is or appears to be parties to be a substantial possibility that before the promisor exercises his choice of events may eliminate the alternatives which would not have been consideration. You guys can read this on your own. It's a mouthful, but long story short, it says a promise that does not actually bind the promisor is not consideration. This applies when the other party promises nothing. Performance is optional. Value is undefined. Bank do give something. They give a credit entry that the law recognizes, but this is where people fail. The correct use of illusory consideration is not saying the bank gave nothing. It's saying the bank failed to disclose the true nature of the value of the exchange. Does that make sense? Right? That brings you into the Truth in Lending Act violations, not fraud and accusation. When you start challenging them on the disclosure, they are given a lack of disclosure. You're not, in essence, saying that what they're doing is fraudulent. You can say that something that they could possibly be moving fraudulently. You can. But that shouldn't be the main core of your argument. Okay? Probably more of a knowledge bomb if they're trying to play this word game with you. Okay? And you can affirm, hey, look, listen, I know this to be true, but I'm not trying to argue the economic truth. All right? I'm just trying to argue the fact that they didn't provide the disclosures that they are required to, as it pertains to contracts, as it pertains to the UCC, as it pertains to the Truth in Lending Act. There was a lack of disclosure. And when I found out that there was a lack of disclosure, if I knew that they was going to make extra money off of my loan, if I knew that they wasn't going to actually lend me money and I was just going to get back, and the truth is the fact that I was going to make, you guys were going to get money this way, I felt like I should have been disclosed that from the very beginning. Okay? So get comfortable with the Truth in Lending Act. Get comfortable with understanding these elements of the law so that when you do get into a situation where you are going to use the illusory promises to your advantage, you are making it about their lack of disclosure. Okay? The other trap I want to talk about is challenging the wrong evidence. People get crushed because they demand the wrong things. They ask for the original note or proof of cash transfer. And this is something you can ask, but it's not something that you lean on. Okay? Under UCC 3-301, it talks about a person entitled to enforce the instrument. A person entitled to enforce the instrument means the holder of the instrument, a non-holder in possession of the instrument who has the rights of a holder. The thing is that they do not need to prove ownership and they do not need to prove enforceability. Or as a matter of fact, they need to prove enforceability. They do not need to prove ownership. That is why show me the original note doesn't really work. Okay? Then under UCC 3-309, it talks about lost, destroyed, and stolen documents in UCC 3-309. It says even a lost note can be enforced. So stop attacking the note and attack the value. What you should demand is under UCC 3-303, proof of value, chain of transfer under UCC 3-203, and proof of lender under the Truth in Lending Act, 15 USC 1602. So you don't challenge the possession, you challenge the consideration, all right? These are things that you can challenge: the proof of value, the proof, the chain of transfer, to see if they can even enforce it, if they're the legal holder in due course, the proof that they are the lender, or if that they provided full disclosure, okay? And here's the last trap, which is trap number 5, failure of consideration used incorrectly. And this is how people use it incorrectly. Most people say there was no consideration, so the contract is void. And in my message before, this is something that I would communicate. Okay. But as I continue to learn, I've learned to really help frame consideration much differently. Okay. When it comes to banking, okay, like when it comes to an actual contract, yes, no consideration, the contract is void. But in the element of where the system recognizes their credit creation or credit extension as consideration, that will be incorrect. That's not the full truth. All right. Here's the real law. Under UCC 3-305, it talks about defenses against failure of consideration. And this is the real law. And this is in A2, where it says a defense of the obligor stated in another section of this article, or a defense of the obligor that would be available if the person entitled to enforce the instrument were enforcing a right to payment under a simple contract. Okay? It also talks about under 1, duress and lack of capacity or illegality of the transaction. Failure of consideration is a defense, but it's not an automatic void. So it does say that when they do not provide proof of consideration, then you can use that. But this means that you must prove that the value was not delivered or was defective. You get what I'm saying? So if you do go from that angle, you have to prove where they have not delivered. Okay? The examples that will work where they didn't deliver is if they can't show the chain of value, if they can't show what was actually risk, if they can't produce ledger entries, if they can't show who funded the transaction, if they can't prove the loan wasn't already discharged by a charge off, if they can't show who holds the risk after securitization. Failure of consideration is the sharpest blade that you have, but most people swing it wildly and lose it. This is the correct use. Now, how to use these traps in your favor. This is the real strategy, so make sure you are paying attention to this part right here. Okay? Make sure you're paying attention. Okay? We're going to get real intimate real quick because I'm about to give you the sauce right now. And for the people who are at the right frequency will be able to get this. But for the people who are not at the right frequency, you're going to listen to the sauce and you're going to ask me the same question. So make sure you're paying attention to what I'm about to say to you. Okay? When you're doing any type of discharge battle, you always want to follow these steps. You want to be able to challenge them on consideration. You want to be able to ask them for the proof. The reason why you do that, you want to do this before you do any type of negotiable instrument, promissory note. Why? Because have them prove that they can even enforce that before you even move forward. Okay? So don't accuse, just ask them for proof. Request the proof. All right? The things that you want to leverage is you want to demand proof of value under UCC 3-303. This will essentially say, show the actual value that you gave. Number 2, you want to require a chain of value documentation under UCC 3-201, UCC 3-203. Show who funded, risk, and transferred the value. And then require the Truth in Lending Act disclosures. Under 15 U.S.C. 1631 and under Section 1632, it essentially says identify the actual lender of value. Challenge the illusory consideration correctly. Use the restatement Section 77. Was the bank's promise real or illusory? Okay? And it's okay to ask that question. All right? If they are going to, what would be real if you just said we're going to extend credit to you? Okay? If you would have said that, you could easily argue. But if I'm under the assumption that I'm going to get an actual loan, then yeah, I wonder what your question would be to that. Okay? Raise a failure of consideration as a structured defense. If they fail to provide this documentation, then you use this to be able to escalate it. The fact that they did not provide this, would you want to notify them of their lack of performance and their breach of contract? And you would do all of this through documentation. Okay? Documentation is what's going to help you. Now, there's a case, Thorne versus Bank of America. Okay. In Thorne versus Bank of America, the court acknowledged the borrowers raised valid questions, okay, about how banks create credit from signatures, but the court didn't rule in their favor. But they did acknowledge the fact that banks create credit from signatures, all right? A loan transaction must have identifiable consideration, which was stated in the case. This is your leverage. Okay, not to scream conspiracy, but to request documentation under the established law. All right? Request the documentation through sending documentation. Do not call them and ask them these questions. Write this down in a letter. Okay? You can find a conditional acceptance, debt validation template in the school community. Okay? You can tap into the school community. I have a whole AI platform where you can be able to talk to it and literally ask it questions about your particular situation, but only in the school community. Okay? You don't win by attacking the system. You win by attacking the elements. The system itself requires. Consideration is the spine to every agreement. And if they can't prove value, they can't enforce the claim. See, here's the thing, you guys. How you're going to be able to move forward is understanding how to be able to formulate documentation where you're able to request and demand the proofs that they are required to give. When they do not provide those proofs, you have now created leverage for you. Okay? This is when consideration fails on their end, when they are not exercising their services. Because remember, consideration is money, goods, services, performance, and rights. So when you ask them for disclosure and they fail to provide to give that to you, that right there is them essentially highlighting the fact that they are violating your rights and moving with no consideration because they don't give a hell about your rights. All right? Use documentation. Take them through the administrative process. When you send a letter, when you start your promissory note, when you do all these extra extremities, I want you to understand that it is a process. It's not something you're going to send one time and then you're going to get the result next time. It's not going to be that. It's going to be in an element of you attacking them over a consistent period of time, and it can take 3 to 6 months. It can take a year. It can take 2 years depending on how big the obligation is, and you have to make sure to move with discernment. Don't just do it because you're excited. Don't just do it because you want to fight against the system. Actually look at your situation and see what would be my reason for taking these steps, okay? Because it's not easy, okay? Just like when I say, boom, make your first 10 grand outside of a job, that's not easy either, okay? So if I told you that both of them take the same effort, I put it to you like this. If you can do one or the other, then you can do the other, okay? If you can discharge your debt, you can start a business and make 10K a month. You can start a business and make 100K a month. You just have to be willing to put in the work and do the things that a person who is getting success in those fields are actually doing, all right? So this was episode 4. Tomorrow, episode 5 will be the finale, okay? We're gonna bring this all together and build a strategy that flips the power dynamic. So if you're done reacting and ready to start moving proactive, you're ready to start operating with structure, join the Fund Yourself Academy on School. Tap into the school community. Be a part of a community of people that are actually growing and doing this and not making excuses, not moving with emotion, all right? Understand the system, beat the system, and fund yourself. Thank you guys for watching the video. If you've gotten this far, comment the word fund me. I love y'all, and I'll see you in the next one.